I will
Thank
support the bill.
you, Speaker Mahoday, for allowing me to speak on this Banking Regulation Amendment Bill. This bill is in fact very significant in the sense that in a country of our size, which has a budget of about 20 lakh crore, the stressed asset in the system is to the tune of 10 lakh crore. That is why I say this is a significant bill. And added to that, the stressed asset of public sector bank, which is the subject matter which we are discussing in detail, wherein the stressed assets are almost 50% higher than the net worth of the bank. So we are virtually sitting on a volcano of liability as of today in the country. Sabhapati Mahoday, before I go into the merit of the bill, let me address one question, whether the ordinance was necessary while it was promulgated on 4th of May. I would like to give a quote of Honorable Sri Jaitley ji in September 2013 while he was in opposition. His quote is, "The ordinance is an abuse of legislative power." So the question today is whether the government intends to abuse the legislative power through ordinance, and if so, to what an extent. Having said that, I would like to deal upon the bill on three different parts, sir. The first one is the merit of important provision of the bill. Second is on the issue of whether the bankruptcy code is the solution, and the last one is the way forward. Sabhapati Mahoday, there are two essential provisions in this bill. The first one is the central government may authorize Reserve Bank of India to direct bank to initiate recovery proceeding against loan defaulter. And the second one is the recovery has to be through insolvency and bankruptcy code. This gives rise to three basic questions, Sabhapati Mahoday. The first one is Section 35A. Section 35 of the Banking Regulation Act already empower RBI to direct bank. So is there any necessity today to bring in 35AA and 35AB? In fact, one of the affidavit filed by the government and the RBI in the Supreme Court during demonetization, this government has said that RBI is empowered under 35A to enforce this. So when they could use 35A, then what is the necessity of bringing 35AA and AB today? The next is, who is RBI? RBI is a regulator. RBI is not a bank manager to ask banks on whom the action has to be initiated. And the third point arising out of this, out of total NPAs, 88% of the NPAs, sir, are in the public sector bank where central government is the majority shareholder. Does the bankruptcy code not provide a provision by which the banks alone can go and initiate proceeding? Is there any necessity for doing so? Or the banks are scared of taking action against the defaulter for fear of ED, CBI and CBC? This is the basic question I am trying to understand, Speaker Mahoday. Having said that, I will come to the second part of my deliberation. The second part is whether bankruptcy code is the solution. Last 20 years, there have been 9 provisions, out of which 6 by RBI and 3 by legal. Whether it is CDR, Joint Lender Forum, 5:25, AQR, SDR, Sustainable Restructuring, SARFAESI Act, and Insolvency and Bankruptcy Code. The sum total of this 9 provision, whether by RBI or by legal, is that the NPA level of our banking system has gone up by 300% in last 7 to 8 years. From a level of 2.3%, it has gone up to 7.6% today. This is the magnitude of the problem today, sir, in the system. Even a country like Africa has got 3% NPA. Sri Lanka has got 2.6%. Malaysia has got 1.6%. So where are we? We are in a vicious circle, Sabhapati Mahoday, out of which 10 lakh crore are embedded in the system. And to make matter more worse, I'll give 1 or 2 examples. I come from Odisha. I'll give one example from Odisha, how the situation is becoming more and more complicated. There is a case. I brought it to the notice of Sri Meghwal ji, Honorable Finance Minister.
Please conclude now.
2 minutes, Sabhapati Mahoday. It is a very, very critical bill. 10 lakh crore is embedded in the system. 10 lakh crore is in distress. So it is important that we spend some quality time in discussing and finding a way forward. I give the case of one particular company in Odisha. They have got 2,600 crore of NPA. And the banker, the lead banker, SBI, what is he doing? He is bringing in some new fellow. And the new fellow is asked that you take over a loan of 1,300 crore, another 1,300 crore will be paid after 25 years. And what is the deal? They have to give, SBI has to give another 1,000 crore to that. Now the fellow who is being brought in, he is under the scanner of PD, he is under the scanner of CBI, he is a chronic loan defaulter. The question is whether you are going to sort out the problem in the system or you are bringing more problem into the system. Can the government, can the finance ministry keep quiet on such issues? I was hearing, sir, a discussion by our certain senior member. In Bihar, a particular case has happened. A genuine borrower, sir, just 1 minute, sir. A genuine borrower who have been paying the repayment on time is affected because of insurance, because of flood, etc. The insurance is not paying, so the company is going to be sold out. Is it the system? Will you not become some kind of a barrier between the willful defaulter and somebody who is the genuine borrower? Now, I will suggest the way forward. Sir, this bankruptcy code, this amendment bill is not going to sort out your problem entirely. This may give you a limited success, but it will not give you a full success. I will ask you that please do consider of handling MSME sector, which is the backbone of the country. Thank you, sir.